also welcome you guys for, this is the first time we've ever done a workshop, a collab with Channel 6, with the caller times on open records, on the Open Meetings Act, which is very important for all the entities. It's nice to see the different entities here, elected officials here. Thank you so much for attending. I know everybody's busy, but this is an important topic that affects all local governments. So thank you so much. I'm going to turn it over to Ms. Clow with Channel 6 News.
Thank you so much. Gabby said that very well, and I have very little to add because we want to get into the information. Typically these trainings, open meetings trainings, typically last an hour, and Public Information Act trainings last an hour. We're going to condense that down. Thank you so much to the city of Robstown for hosting this. I am thankful that so many public officials are here. We have Kelly Shannon here, who is the Executive Director of the Freedom of Information Foundation of Texas. And that organization, if you're not familiar with it, you should become familiar. They have an open government hotline, which is staffed with attorneys who are experts in the act, who answer questions, and that is such an incredible resource. Olivia Garrett is an education reporter with the Corpus Christi Caller-Times, and I am the producer who manages 6 Investigates for KRIS 6 News. I'm going to turn this over to Ms. Shannon so that we can get started. Kelly, can you hear us?
Yes, I can hear you. It's not super loud, but I can hear you. Can you hear me okay?
We can, thank you.
Okay, hello everybody. Rachel just sent me a photo of the audience, so it looks like we have a good turnout today, and thank you. I know there's a wide variety of people there in the audience. I'm Kelly Shannon. As she mentioned, I'm Executive Director of the Freedom of Information Foundation of Texas. It's a mouthful, but I've gotten used to saying it over the years. I've been in this role a little over 10 years. Before that, I was a news reporter for many years and used the Public Information Act and was aware of the Open Meetings Act. So, I've been around these laws and knowledgeable about them for a very long time. And now in the job I'm in currently, I get to help educate the public about it and help individuals who are trying to use the laws who may, encounter some roadblocks. We also help government officials. I understand there's several government officials there in the room, so thank you all for being there. We're a resource for everyone, so that's what we like to point out. The Freedom of Information Foundation has been around since 1978, and we, it started out, it was formed by journalists, but it quickly grew, and it's not just for journalists, it's for individual citizens, government, everybody. So I will present you kind of this condensed version of our training that we do on the Public Information Act and the Open Meetings Act. This PowerPoint was put together by Tom Williams of the law firm Haynes and Boone. He's on our board. He's one of the attorneys on our board. And for those of you who may have been at the event on Monday evening, he did the presentation then. So just so you'll know, it's the same slides that were shown then, different presenter. I am not a lawyer. As mentioned, my background's in journalism, but I'm around these lawyers all the time and get briefed by them and go to their trainings. So I go out and speak to community groups, classrooms, et cetera, about these laws. If there's something that I can't answer, I will not try to, fake it. I will just say, let's talk to one of the lawyers. So we've got that FOI hotline that Rachel mentioned. I also should point out that on our website, which is foift.org, we have a lot of great resources, and if you look at the lower bottom right-hand part of the main page or almost any page on the website, there's a whole list of resources, and we're always adding to them, but there's links to the Public Information Act, to the Open Meetings Act, basic police information, all this stuff. So make use of that if you can. All right, so let's just kind of jump right into it so that we can move through and hopefully have time for some questions. We'll start with the Texas Public Information Act, and these are like 10 highlight things to know about the Public Information Act. There's tons more to know. That's why there's so many lawyers that have to get involved in these things from time to time, and there's lots of training that goes on. But to trigger the Public Information Act, the request must be in writing. So that's something to keep in mind. It's not a formal letter. You know, there's no magic words or anything, and it can be submitted by email, regular mail, hand-delivered, or through a government-approved website portal. But that putting it in writing triggers the Public Information Act. You can, of course, ask for information, and many times government agencies understand, hey, it's much easier to just hand over the information and make it publicly available through making a Public Information Act request. Sure, fine to ask verbally, but ask in writing to trigger the act. And one thing to note, if you do make this request in writing and you're sending in an email or mailing it, and that government has designated one email address or a physical mailing address for these requests, that's where it has to go. You can't just send it anywhere in the city government. It's got to go there. So that's the point on that. And next slide, I guess. The information that you're requesting under the Public Information Act has to be produced promptly and without delay. That's part of the law. And ours in Texas, our law is stronger than some states with this deadline. So 10 business days, and if the government cannot provide it within the 10 business days, then they need to certify that fact and then set a time and an hour within a reasonable time period when that information will be produced. So let's say you're requesting a whole lot of information and it's going to take them more than 10 days to round it up. That's when this would kick in, but otherwise produce it promptly. And there is a myth that a governmental body has 10 days to provide the information. No, it's supposed to be presented promptly and without delay. Your fingertips, or it's easy to access, that information needs to be handed over right away. It's not like, I'm the government agency, I can wait until the 9th day and then shoot it over to you on the 10th day. No, that's not what the law calls for. All right, next slide. Thank you, Rachel, for advancing these slides for me. So, responding to a government's request for clarification. So a lot of times a governmental agency may say, hey, I don't really understand your public information request. Can you explain it a little better? Can you clarify? And oftentimes this is done in good faith, especially if it's a very vague request. Sometimes it's not done in good faith, to be honest with you. It's just kind of a delaying tactic. So we would hope that all governments are acting in good faith on this, and they're asking for a clarification. Well, if so, you, the requester, need to respond within 61 days, or that request is deemed to be withdrawn. And assuming that the clarification is asked for in good faith, then their deadlines with the Attorney General's office ruling process and everything don't kick in until then. We'll get into all that in a moment. But the other things that I'll say about, the sooner that you respond, and Tom pointed out this on our session on Monday, the sooner you respond, the better. And your response might even be, no, I'm not going to clarify it any further. I think it's very clear as it is. But that's still your response, and you need to respond. Otherwise, it could just be deemed, they didn't respond. So, and if any of this is unclear, feel free to ask now, but we can also try to clarify it further in the Q&A towards the end. All right. Next. Cost estimates. So sometimes when you're asking for information, it might just be very simple, a one-sheet thing that you're asking for. Or if it's online somewhere, they can, the government can direct you to the URL where it is online. But sometimes, these requests for information do cost money because it involves some staff time to round it up, or it involves redacting and copying pages and that sort of thing. So if it's anticipated to exceed $40 in cost, the government must provide the requester with an itemized statement detailing those estimated costs. And then within 10 business days, you've got to, either accept it as the requester, you accept it, or you modify the request. Maybe you've decided, this is too expensive, I need to narrow it down, I don't want this much information, so that would be modifying the request. Or if you think you're being overcharged and being, railroaded on this, you can submit a complaint to the Attorney General's office. But at any rate, again, do respond, because when you get this cost estimate, even if it's just to say, okay, yeah, I accept it, you need to respond to that request. Otherwise, then it could be withdrawn or considered to be withdrawn. And I'll also add, should have said this at the beginning, a lot of this I'm putting forth is from the requester's point of view, the regular citizen's point of view, which is what the public information is all about, is so that citizens can get the information from their government, right? So when I talk, a lot of times I'm talking from the requester point of view, but this is all obviously super important to both the government officials who are in the room and the requesters. It works both ways, and we ought to all be aware of every aspect of this. So with that caveat, next slide. You can be required to pay a deposit on this cost estimate if the estimate's going to exceed $100 or $50 if it's a very small government entity. They may require you to make a deposit. Well, there's a logical reason there. If it's going to cost a lot of time and effort on the government's part to get all this information together, and then, you don't ever go pick it up, that's a problem. So by putting down the deposit, some governments want to know, yeah, they really do want this information. We can proceed with gathering it up, and then you can, pay the rest later. And sometimes the deposit is the full amount of what is going to be charged. So if you fail to do that deposit within 10 days, the request can be deemed withdrawn. And the other point here is about the Attorney General rulings, that those kind of are all dependent upon the request for the deposit being received and put out there and then received. So that kind of kicks those Attorney General rules into gear, which we can talk about again in a moment. I'm trying to check here. One thing that we want to, I'm looking in my notes from this whole subject matter, and the government body does not have to charge for information. A lot of them will charge, but they do not have to. And sometimes, very often, if it's just a quick, 1 or 2 pages, something very easy, they're not charging, and that's, it saves them time and money really not to charge, and it's good for you guys who are requesting it too. But they can. So, it's kind of it's a judgment call, and you can ask for a waiver, and the government can grant that request and waive the charges, but it just is a case-by-case situation. But there's lots of different cases that we hear about where there are exorbitant cost estimates, that things are really being, overstated in that cost estimate. And that Attorney General complaint process that we mentioned a moment ago, there's a cost complaint. There's a general Attorney General complaint, informal complaint process for just the overall Public Information Act, and then more specifically, there's a cost complaint process in the Attorney General's office. And that one, even though it's rather informal, there are some teeth in it to where if you are being overcharged, there are some, refunds and things like this that the Attorney General's office can put into place. So that's something to remember too. Their website will have a lot of information on that. That's another good place to look at, is the Open Government section of the Attorney General's website. Is that clear as mud? Does that seem to be understandable? All right, next slide. All right, definition of business days. So a few minutes ago, we were talking about, you've got to present the information promptly, or within, 10 business. And then business days also applies when it comes to seeking that attorney general ruling if one is sought. And various things are geared around business days or the Public Information Act. Well, okay, this takes a little bit of explaining here. It's super important though, so bear with me. Up until the last legislative session, we did not have a definition of business days in the Public Information Act. So, you would kind of assume, yeah, we all know what business days are, like not Saturday and Sunday, not holidays. But then there's other days that can occur that, may not be a business day, like, all right, a government had to shut down because of flooding. Let's say a hurricane, hits your area and there's flooding in the office or everybody's closed down. Well, always, according to Attorney General guidance, holidays, Saturday, Sunday, these days when there's a inclement weather condition, these were not considered business days. And it was obvious. I mean, we all understand about this. And, or maybe it's like, Thursday is Thanksgiving and the office is closed on the Friday after Thanksgiving. But also the Attorney General's office gave guidance that if there was a skeleton crew day or certain optional holidays, then governments could take them. Well, we ran into a lot of problems, once the pandemic hit in 2020. Before that, it was almost always these other, these obvious days we talked about, or the occasional flood or snowstorm, hurricane, what have you. But then the pandemic hit, and what happened? We all know it. Offices closed. Everybody started not going into the office and working remotely, or the physical office was closed. We know there were a lot of governments that their physical door was closed, even though there were people back there working. But government started saying, around the state, started saying, well, we're not physically open today, so that means we're closed for Texas Public Information Act requests. And this just, started, maybe when it all started, everybody thought this was only going to last 2 weeks or whatever. Well, what we got into was weeks and weeks and months of some governments saying, we're closed. We're working on skeleton crew. Our physical doors are closed. We have people working at home. We're not open for Public Information Act. So it was like a wild, wild west of everybody just deciding on their own when the Public Information Act applied and when it didn't, when it came to business days. So this was a problem, naturally. I mean, but, we're talking months, some cases even a year or more, when people couldn't even get Information Act requests in. And mind you, most information now is available electronically. So even if you're working remotely, you can respond to a Public Information Act request if you're a government and say, look, here it is on our website. Here's the URL where your information is. Or here's the electronic documents you're looking for. Boom, I'm emailing it to you. So all of these facts come into play, and we transparency advocates worked very hard to get this passed to where there's a real definition of the business days. So it is spelled out. There was a bill passed last session, House Bill 3033, if any of you want to look it up. And it spells out what are business days under the Public Information Act. And there was a lot of negotiation that went on with this because, school districts would say, well, wait a minute, we've got 2 weeks that we're closed around the winter holiday and Christmas, right? How does that apply to us? So the way it's all written is, you've got your regular, Saturdays, Sundays, state, federal, legal holidays are not business days. But in addition to that, a governmental body can designate up to 10 additional days in which they're closed for the year or they're operating on a skeleton crew, and those can be non-business days. But you really have to follow the specifications of this. So, for instance, you might be thinking like, okay, July 4th falls on a Tuesday, and the Monday before is going to be one of our non-business days. Or it could be those couple of weeks in between Christmas, around Christmas and New Year's, et cetera. But what you have to do, if you're designating these 10 business days, the government needs to do it at the beginning of the year. And so it's not just springing on everybody at the last minute. Oh, by the way, we're not having business days this next week. No, you need to specify it in your calendar. And the remote work is irrelevant in determining a business day. I mean, you can be working remotely, but it's still, according to your calendar, it can be a business day. So I hope that's understandable. I probably went on longer than you might expect about that, but there's a lot that went into this, and we're very glad that this bill just got passed in 2023. Next point is, if you're trying to get information and a governmental body is trying to withhold that information from you, generally they must seek an attorney general ruling. There's some information that can certainly be withheld without an attorney general ruling, like, W-2 forms, social security numbers, things like this. But generally, or, if the government has gotten a ruling on this very specific point in the past, they can rely on that previous determination. But generally, the government must seek an attorney general ruling if they want to try to withhold the information within 10 business days. Again, here we are with the business days business again. But it's also important to note that a requester does not have to sit around and wait for that attorney general ruling. They can actually file a civil lawsuit seeking the information without waiting for the ruling. So, you can go straight to court and try to compel the release of that information. And you can do both. You can have two things going simultaneously. You can be waiting on the attorney general ruling, and you can be in court seeking it. And this has all been upheld by a Supreme Court ruling, and before that by general practice. But at any rate, you have these two different paths, and you don't have to wait on an AG ruling in order to file suit to try to get your information. We understand not everybody has the money and the time to file lawsuits. I mean, that's something we recognize and point out, and that's why it's just so important that the law work as it should, because everybody shouldn't have to be running to court to try to make the law work. It's up to all of us, people in government, the requesters holding government accountable. It's up to all of us to make it work as it should, smoothly. All right, next. Okay, this has to do with police information, and this law kind of got the term assigned to it, the dead suspects loophole, which, really what it has to do with is people who are deceased who died in police custody. And it just kind of got known as dead suspects loophole. But that got repealed in the last session. So this is another really important law that has come into play. Back in the 90s, there was a provision put in the Public Information Act that was really meant to protect the innocent, people who the charges were dropped or they weren't convicted. And it said, if the case did not go to a conviction or a deferred adjudication, other than the basic information about the arrest, et cetera, just the other documents and video and everything could be withheld if the case did not go to conviction or a deferred adjudication. And you can see how that would be, like, say you were falsely arrested, they got the wrong person, or they realized, no, actually this person didn't commit a crime, the charge has been dropped, or, it went to court and you were acquitted, right? So all that information, the narrative, videos, and all that could be withheld in those cases because it was meant to protect the innocent. Well, some police departments around the state started using it to withhold information when someone had died in police custody, hence that dead suspect loophole name that it got. Because you can see if they're dying, like say they were arrested last night and died today in police custody, or they're in jail awaiting trial or whatever, that case is not going to go through court and get to a conviction or a deferred adjudication because so it was a misuse of the law as it was written. It was misinterpretation, misuse of it, abuse of it, however you want to call it. And so now this House Bill 30 that was passed in 2023 makes it clear that exception is not to be applied when somebody who's being depicted in the information has been deceased. So I hope that explains it, but that's a really important new law that we've got, and we're keeping an eye on it to make sure that it's doing exactly what it was intended to do. So it's very new, just started September 1st, 2023. And let's see, next slide. Okay, attorney's fees when it comes to, like, if you have to go to court to try to get information, let's say a government entity is refusing to release the information, and, maybe they even get a ruling that allows them that from the Attorney General's office, but you feel like this should be public information, and you've either sued after there's an AG ruling or you're suing right away. And as we mentioned, not everybody can afford to sue. And one reason everybody can't afford to sue, is because there's attorney's fees, right? So if you have to go to court to compel the release of the information and you win, it's an option for, if it goes all the way through court and you get it and you win, it's an option for the judge to award attorney's fees, which, as you can see, would be really important to the requester and really important to the ability to find an attorney who is able to take on your case. Well, in certain cases, if a government discloses the information, like on the eve of trial or even during trial before there's a final judgment, so it's not, it can't be said that the person suing has prevailed. It just kind of becomes moot because they've handed over the information. But you've already spent months and months with discovery and trial suit, et cetera. Well, there's a problem. There's been a ruling that does not provide for attorney's fees in that case. So we are working on that again this legislative session to make sure that, if court action has been initiated and the information is handed over at the last minute, like on the eve of trial or during trial, that there still is a provision for the option of attorney's fees. And we'll keep everyone posted on that. We're hopeful that that one will get cleared up this legislative session. Next. All right. The database of rulings, that House Bill 3033 that we mentioned earlier that got the business days defined, well, it included a few other things about the Public Information Act, too, so it's a really good bill to go back and look at. But one of them is it calls for this database in the Attorney General's office, a searchable database for their rulings. So that's when, the government goes and they seek a ruling from the Attorney General of, can we withhold this or not? And this database, I have to tell you, it's not the easiest thing to use, but it is there. So like if you're looking for a certain government entity or a certain time period, or the actual case number you're looking for, it's there. It's not like an all-encompassing search engine, but it's making the rulings a little more easy to pull out and look at than it was before this database was online. So there's the site where you can find it, or you can go to the Attorney General's website and find it in their open government section. Let me see if there's anything else. Yeah, as Tom mentioned on Monday, it's good for tracking a specific request or following a certain governmental body, like a city, like Corpus Christi or whatever, Robstown, whatever you're looking for. And it's at least a tool for you to use and to kind of zero in on things. So I think that's our last slide on TPIA, isn't it, Rachel?
It is.
Okay. Before we go into this one, now we're going into the Texas Open Meetings Act. But I'd like to repeat something that Tom, our lawyer who presented on Monday, pointed out. And he really is great at explaining this, but there's different roles in the AG's office for the Public Information Act versus the Open Meetings Act. So this is kind of a thing that really differentiates the two acts. So with the Texas Public Information Act, as we've mentioned, there's that AG rulings process where governments can seek a ruling and say, hey, give me guidance. I think I should be withholding this. May I? Basically asking permission, getting their ruling on it. With TOMA, the Texas Open Meetings Act, there's not that ruling process. That's just not happening. There's a general opinions process where there might be like an overall opinion that's issued by the Attorney General saying, okay, this governs the Open Meetings Act in this kind of broad way, and everybody can use that to follow and have a guidance. But it's not going to be on specific cases of government seeking a ruling or individuals seeking a ruling about the Open Meetings Act. So as Tom was explaining, we have this real large body of law regarding the Public Information Act, in large part because of all these rulings and then people going to court to argue about the rulings, but not so much with the Open Meetings Act. So it's not like a dispute resolution. It's not like a dispute resolution case, as I've mentioned earlier. And let me just check this really quick. Okay. So let's start off with the Open Meetings Act. It requires that every regular, special, or called meeting of a government body be open to the public except as provided by law, which we'll get into in a moment. It also requires that the public be given prior notice of the time, date, location, and subject matter of the meeting. That makes sense. Obviously, people need to know what the meeting is going to be about so they can decide whether to go and whether they want to speak out, etc. All right, let's go to the next slide. All right, can the government representatives meet one at a time in person or by email? Okay, yes, but you can't do that knowingly trying to circumvent the Open Meetings Act. So you can't have a situation which is sometimes called a walking quorum where, hey, I go over and talk to so-and-so about this issue, and then knowingly that next person on the board or the commissioner's court or whatever is going to go and then talk to the other person about that various issue. Then the next, that very issue, and then that person goes. So you kind of have like this daisy chain effect where there's a discussion happening, but they're not all in one room in a meeting. And this can also occur these days by email or text or other things too. So you can't really be doing that if you're trying to circumvent the act. And that's a real key, is the intent. So it's like a series of communications outside of a meeting where the participants know there's a quorum discussing public business. I hope that makes sense. This has gotten cleared up, or maybe not cleared up, but gotten legislated on a couple of sessions ago after a Court of Criminal Appeals ruling on the issue. Many of us thought it was already clear, but now it's even kind of more specifically written in the law. We should note that the Open Meetings Act does allow the public body to have a written discussion outside of the meeting if they put it on an online message board that's accessible by the general public. So the city of Austin has this going, excuse me, where they've got an online message board, and one council member is saying, hey, guys, what do you think about this, and having the discussion, and then they can all chime in on this online message board, but the public can see it. So they can do that between meetings, but it's not constituting a violation of the Open Meetings Act. And these have to be available in real time and searchable for at least 30 days, and there's a few provisions in the law. I don't know if any governments in your area have this. Rachel, do any of you know about that?
They do not.
Happening in your area?
No.
Yeah, it's not real widely used, I don't think, but it's a tool and it's there. So that's something for government officials to think about. And it, helps with communication between meetings, and then you're not violating the Open Meetings Act. All right. Next. Can you meet by telephone, video, conference, internet? Yes, if you've got got the quorum of the body present at your physical meeting location. And for some state bodies, only the presiding officer has to be there at the physical meeting location. If you're doing this kind of meeting where there are going to be, people coming in remotely, the public has to be able to hear and see the meeting. So you've got to have the right equipment and the right setup so that the public can listen and participate. And we should note that during the pandemic, there was a governor order that got rid of some of this quorum location requirement because, we weren't supposed to be in groups. Everybody remember what a short while ago, right? We weren't supposed to be in groups of more than 10, right? So that was suspended for a bit, but that exemption has ended. That has been lifted. It expired. Next. What must be included in a posted meeting notice? The date of the meeting, time, location, and business to be discussed. And that business to be discussed on the agenda, it needs to be specific, not, paragraphs and paragraphs or anything, but if it's a very big item, like selection of a city manager or whatever, it needs to be specific so the public definitely knows what's coming up. That's all pretty self-explanatory, I think. Next slide. How soon must it be posted? Well, you need to post in the location accessible to the public for at least 72 hours before meetings. There is a provision where if you're having an emergency meeting, it can be a 1-hour posting. So that would be a situation like, the hurricane hits and the county commissioners need to get together to decide on, here's where we're going to deploy crews. Here's the sandbags. Here's where the emergency shelters are going to be. In those cases, you can do a 1-hour posting, but otherwise it's the 72 hours. And then in addition to this physical posting that's accessible, they now also, many governments need to post on their internet, on their website if they've got one, and that's under a new law that was recently enacted. And then for statewide jurisdiction agencies, 7-day posting prior. Well, that's an obvious thing too. It gives people time to travel if they want to come in person. It's covering the whole state. So there's different posting requirements for them. Next slide. Can the public pick the items that will be on the agenda? No, that the public isn't picking what's on the agenda, but there is a 2019 law that allows anyone who wants to speak on an issue on the agenda at a public meeting before or when the item comes up for consideration. So this is the public comment on the agenda items bill that was passed in 2019. And the governmental body can establish some reasonable rules, like some time limits, for instance, so that people don't just get up there and speak an hour each or 2 hours each. You can set some time limits that are reasonable. And there's also different provisions for non-English speakers. And during this public comment, the government cannot prohibit criticism of the governmental body. So those are just some important things to remember on that. Let me see if there's anything else that I wanted to point out on that one. The other thing, though, that comes into play with all this is for items that are on the agenda. So you have to be allowed to comment before or when they come up. Many governmental bodies have just a general public comment session, and that's not mandatory, but it's been done for years and years, and it's a great thing. It's important for the governmental body to hear from the public generally. So that is not covered by this. and not mandatory, but it's something to know about. And yeah, I think that's all I was going to say on that one. We can answer further questions if we need to later. When there is a final vote or action taken, that needs to be an open session. So even if the governmental body went into a closed session or executive session, as it's called, for the allowable reasons to deliberate something, when they take that action on it, they've got to come out and do it in public in an open session. That's just all there is to it. So, next slide. When is it permissible for them to go into this closed session or executive session? Well, here are some of the reasons they can, like consultation with an attorney to obtain legal advice, deliberations about buying real estate, certain personnel matters, and that would have to do with like more individualized personnel matters, not just a general discussion of, oh, we want to increase the size of the police force in our city and it's going to cost X amount of money. That's not what's meant here by personnel matters. This is about individual issues with personnel. Deliberations about security devices or certain economic development negotiations. So these are some of the reasons that it's allowable. But, you know, the governmental body has to state, you know, why they're going in to the executive session. And the item's got to be on the agenda. So you got to state this reason, and the item's got to be on the agenda, and there's got to be some description of it on the agenda, too. All right? Consequences for noncompliance. So under the Open Meetings Act, we can have two different remedies, civil and criminal provisions, if we feel that a governmental body is not following the Open Meetings Act. So the civil remedies are, you know, so the lawyers in the room, you'll know what all this means, but you could get an injunction, for instance, to, you know, prevent the meeting from happening, or you can get a mandamus for, you know, the noncompliance. I'm trying to see here if I had anything else to add on that. On the criminal side, these are misdemeanors, and those are handled by the local county and district attorneys. But civil is what you hear about more often, but criminal definitely happens, and those are misdemeanors, and people do get arrested and charged with those crimes. All right. Yes, anyone can file a civil suit. Any interested person can file an injunction or mandamus to stop or reverse a violation of the Open Meetings Act. That doesn't mean it's going to necessarily happen, but you can seek it in court to reverse that decision or something that's happened when there was a violation of the Open Meetings Act. And the court can award attorney's fees if they ultimately win. That's discretionary, so it's a can-do kind of thing, an optional matter for the court. But, you know, on the flip side, if a citizen goes to court and loses, they could have to pay some attorney's fees as well for the governmental body. So this gets into a lot of different case law and legal advice. So people have more questions on that, I might want to refer you to one of our FOI hotline attorneys. But that's good to know that that's a remedy, right? And is that our last slide? It is, isn't it?
Was.
Hello?
Yes, that was the last slide. So we are going to switch over to the Q&A portion. If anybody has filled out a form and they have a question for us, I can come grab those. Olivia will start.
Yeah, so we had a question from a resident, and it was about a specific item that had been approved by a local board they were interested in. And so the crux of this question is that if an elected board has hired a company for a project, and then that company has hired someone else, like a project manager, is the name of that project manager who is hired by the company, not by the elected body directly, is that name public record?
Most likely it is. And here's the part of the law that I want to send you to. In 2019, we worked really hard in 2017 and finally got it passed in 2019 to shore up the parts of the Public Information Act that deal with contracting transparency. And there is now a provision in there, long story, but there was a really bad Texas Supreme Court ruling that this law corrected. And this part of the law points out that the public has the right to look at government contracts and all sorts of parts of the government contracts, and it calls out certain super public information. So like the price, the amount of taxpayer money spent on the contract, the terms of the contract, what promises are being made, what are the deadlines, and in that, it also calls out description of services and subcontractors and certain like deadlines for vendors. So in that case, you're getting into who the vendors are. But I think what this person's asking about is even like kind of a major subcontractor. It sounds like the project manager, right? And so the section of the law that y'all want to go look at for this is the Texas Government Code 552.0222. 552.0222. And that spells out the super public information that's available in government contracts. And there's many other parts of the contract, and frankly, many of us believe the entire contract should be public, but every now and then there's an argument over a trade secret or something like that. That can come into play. But for the most part, the government contract needs to be open, and particularly this super public information. And I believe that this project manager question would fall under what's called for in the contract, the main items in it. So, yeah.
Perfect. Kelly, that same resident also asks if an attorney must always attend executive session. So are there some cases in which an attorney does not have to attend that session?
Okay. No, they don't always have to be there. But if that governmental body is saying that they're going into executive session to get attorney advice, or because they're going in for attorney-client privilege or advice of an attorney, certainly the attorney must be there. And then furthermore, that attorney actually has to be giving them advice. There has to be an interaction. You can't just stick an attorney back there and then call it attorney-client privilege, so we're going into executive session. And we do see that happening from time to time. So the attorney must be there for that, and it must be an actual giving of legal advice. But there's other things they can go back there for to talk about where you're not needing attorney advice or needing an attorney there. So no, the attorney doesn't always have to be there. And let's remember, some smaller governments don't have an attorney on staff that's going to be at every meeting. Sometimes they're calling one in just when they need one, or to outsource information, Public Information Act requests. So no, they don't always have to attend the executive session. And when they do, and the attorney-client privilege is being used, we better be following the law.
Thank you. So the next question, a resident wants to know about the limitations on board members to respond to the public during public comment. Are there ways that the board can allow for feedback from the public or can respond in any way?
Okay, so yeah, the Open Meetings Act describes some of this, and let's say you're in the public comment portion, and the city council or county commissioners is there, and they're listening to what the public is talking about. You're not supposed to be giving a lot of feedback or engaging in a debate or anything with the person doing the public comment. You can, like the government official can ask a question here or there to clarify or make sure they understand what the person is talking about, but not a big back and forth getting into a debate. And when the government official is commenting, we're not supposed to be veering off onto non-agenda items. So that's just some of the general guidelines on that. And again, if you have a real specific question about something that happened, that's arising and making you ask this question, probably the FOI hotline might be a good place to go, and you can describe the specific situation and see what the attorney thinks.
Kelly, I'd like you to expand on the change to the law in 2023, specifically about meeting posting requirements. So if a municipality has consistently posted on their website and then they stop doing that to notify the public of their meeting, is that allowable?
Okay, well, I mean, my understanding is under the new law, many more governments have to post on their website. So always we had this posting of the meeting, like down at the county courthouse or city hall, like the physical posting of it. And now many of them have to post on the web as well. So, you know, are we saying, did they post it for this one meeting and then took it down before the meeting? Or are we saying that governmental body just kind of stopped putting on their website altogether for every meeting? What is the question asking?
So there have been specific instances where a governmental body typically posts on their website, but then they may elect not to post a meeting here or there, and when the public inquires, they really don't want to tell the public a meeting is happening.
Well, I mean, with the caveat, I'm not a lawyer, but that doesn't sound like what should be happening. They should be doing the physical posting, and if they've got the website, they should be putting it on the website as well. And that probably is what the law requires, but again, a lawyer could talk about that. But what good common sense and customer service and the spirit of the law calls for, it's just put that thing on the internet, put it on the website, let the public know what's going on. That's the spirit of the law, and that's good customer service by the government.
Okay.
I can't hear you. I'm sorry.
Sorry. Another question is, what can individuals do if a government body is stalling in supplying basic information? For example, the basic information related to an arrested person, an arrest, or a crime.
Okay. So first off, I'll point out, earlier I mentioned our website, foift.org. We have those resources, and in that lower right-hand corner under the resources, you'll see an item on basic police information. And so that has to do with, you know, all the basics like time of the crime, arrest, circumstances, things that we, for many years we always called the front page of the police report. And I'm assuming that that's what this person is asking about, is supplying this basic information regarding an arrest, crime, arrested person. So be familiar with what that basic information is that they're required to release. And it goes back to this Houston Chronicle ruling way back in the 70s. So, you know, be aware of your rights and what that court ruling is. And you know, you can talk to the local government and point out, hey, these are the things that you are supposed to release, and you're supposed to release it promptly. So, you know, sometimes just talking it through like that really helps. But you can also, file a complaint if it's something that's taking a really long time or it's a consistent pattern. You can file a complaint with the Attorney General's office, and this is that more informal general complaint process that I talked about way earlier. There have been a lot of situations where this has arisen, and sometimes local newspapers have even gone to court over it because, you know, the whole point of all this is we're trying to have the public informed about what's going on in their community, and crime is something that is definitely of interest to everyone. So, you know, there's really good reason to make sure this information is produced promptly and without delay. So, go to that local government, make sure they're aware of what they're supposed to be producing promptly. Show them that list of items from that Houston Chronicle ruling way back when. If you're still having problems, file the Attorney General complaint and see if you can get the Attorney General's office to get involved. And then, the other thing is there's always the lawsuit avenue, but as we've mentioned, not everybody has the ability to file a lawsuit, and you would hope it wouldn't come to that. I mean, I would hope that there'd be a way to work it out on the very front end with that give and take and, persuade the local government to follow the law. But then there are these other steps that have a lot more force in them that you could take, too.
Kelly, our next question is, how do we gauge whether a cost is exorbitant?
Okay, that's a great question. I get a lot of cost questions at the office. So there are prescribed, and on that resources on our website, there's a cost complaint rules item that you can click on that shows what the allowed costs are, and that's set by administrative rule by the Attorney General's office, but it's been set there for a long time. So you'll see things even on there that we don't even use as much anymore, like microfilm and such. But bottom line is it talks about the price that can be charged for each item that's produced. It talks about the labor charge of $15 per hour. And, there's a lot of labor involved in rounding up the information. And then if computer programming is required, I think the allowable amount is $28.50 per hour. So you can look and see what all, and by the way, the computer programming, that means when there's some complicated computer work that has to be done. That doesn't just mean popping out a spreadsheet that already exists or, that sort of thing. So you can look at what can be charged, and then you're supposed to get that itemized bill if it's over a certain amount and look at it and see if it seems reasonable. And if you're not asking for the world in your information, you're not asking for a really long span of time of emails or, information that they're going to have to dig around. If you know that it's pretty easy to access, yet they're charging you 100 hours of labor or something, you can use your common sense to add it up and go, this sounds really high. This sounds out of whack. If you do think that's the case, you can go through that AG cost complaint process I mentioned. If you do have some doubts and think, well, maybe I over-asked, I've asked for too much, and it really is going to cost a lot, then you, the requester, have the right to pare it down and make a more precise request. And we always advise people, make your Public Information Act request as specific and narrow as possible, because that helps you get the information faster. It helps the government get the information more quickly and not as likely to ask for clarifications. But it's a case-by-case basis, and we do hear about cases where people get like $100,000 estimate on costs. Well, sometimes those are meant to deter the person from wanting the information. They really are not made in good faith, and that is a problem, and that's when you really need to be doing the cost complaint process with the AG's office. So sometimes cost estimates are used to intimidate people and make them back off and either withdraw the request and just, oh, never mind, I'm not going to mess with that, or to make it a lot more narrow to where you're really not getting what you want. Another thing to remember on costs, and I give people this advice, is remember, you don't have to ask for everything in one request. If you're asking for, say all the emails between two different people in government on this particular topic, well, maybe just over the past year or over the past 6 months gives you what you need. I once had a caller to the office who was asking for all the emails on this particular topic that went back all the way to when the internet came about in the 90s. And this was just a couple years ago, right? And I was like, whoa, wait a minute. Why are you asking for all of that? Don't you know that that is a huge amount of time and labor, and it's going to have a very big cost estimate on it? And is it really practical for what it is you're trying to do? And the person was like, well, no, I could probably ask for a shorter amount of time. I was like, yeah, do that. It's good for you, and it's good for the government. And you know what? One thing that I probably should have said early on, and I often say in these presentations, is government officials cannot ask you why you want the information. That is not allowed. You can tell them why you're looking for the information, but they can't ask you why you want the information or what you're going to do with it. That is just off limits. Now, if you want to call someone like me or an attorney or someone and talk to us about what you're trying to do and get some help and coaching on, well, here's a good way to ask for that information, that's fine, but you don't have to tell the government official why you want it. I went off on a tangent there, but I think it's important to point out.
Thank you. And so another question is, are economic development organizations that are partially funded by taxpayer dollars subject to open records requests as well as to open meetings law?
Okay. First off, I'm going to take the open meetings part of it. We mentioned a minute ago, there were some times when governments can go into the closed session on economic development negotiations. So that kind of covers the open meetings part of it. But any kind of decision they make on it has to be out in public and has to be a public decision, right? Now, as far as the Public Information Act, this also was included in that 2019 contracting transparency law that we worked so hard to get passed. And there is a whole section in the law that deals with when economic development organizations are subject to open records requests to the Public Information Act. And there's some thresholds, like if they get over $1 million in public money and, certain things. So if you want to look at that part of the law, it's in Texas Government Code, Subchapter J, Section 552.371. So Subchapter J, 552.371, and that'll explain to you, when an economic development operation is considered a government entity for purposes of the Public Information Act.
Kelly, we're right at 10 a.m., but we have several more questions. Well, not several. We have a few more questions. Do you have a few more minutes?
Yeah, if you guys are okay to go a few more, I can too.
Yes, they have given us permission.
I hope I can hit you then.
Okay, so the next question is, can agenda packets be requested before the meeting?
Yeah, you can certainly request agenda packets before the meeting. And in fact, I used to, as a reporter, somewhere I worked one time, I covered county government, and they always released the agenda packets. And as a reporter, it was really helpful to me because I could kind of do my research ahead of time and understand more what they're talking about, and so could members of the public. And frankly, to you government officials in the room, realize this can actually, when you're dealing with reporters, it can actually lead to some really good stories, positive stories about what you're doing as a government official. Like, is there a certain new project, a water project that's coming up, or a beautification project, or, some good things you're doing for the community. And if there's a little bit of background and notice ahead of time, sometimes these get reported on before the meeting, makes people want to come to the meeting and listen in, highlights what you're doing. But yeah, you can request the agenda packet. Not all governments are real responsive on providing the whole agenda packet promptly. Certainly they have to eventually because it's a public record, but it would be in their best interest to provide it before the meeting, and you can certainly request it before the meeting.
And so the next question is, if someone wants to view public records in person instead of getting a copy sent to them, does there still have to be, will a cost be assigned for that, or could the cost be eliminated if you come in to view in person?
Okay, so for the most part, the cost should be eliminated, because you're not having like to send out physical records and such. But, it could come into play, like if there is a labor charge involved that they need to round up the information you're asking for, that could come into play. But for the most part, just coming in and looking at the records, or telling them you want to look at a whole certain batch of records and then you thumb through and find what you're looking for, that can eliminate the cost assessment.
And so this question is about NDAs. Are any details about the topic of an NDA, can that be provided to the public?
Oh, okay. Not being a lawyer, but I've heard a lot about NDAs of late. Is there any more specificity about like what kind of NDA we're talking about here? Because in general, government shouldn't be doing NDAs, but what are we talking about?
So, Kelly, I assume that this is referencing some of the industrial companies coming into the area, such as Avena and Tesla. Very often they enter into NDAs with the governmental body, and I think the question is, what sort of information is public?
Okay. Well, all right, this has come into play. I haven't dealt with maybe the scope of the ones you're talking about with Tesla, but we've got governmental bodies trying to write NDAs for all sorts of things these days. And what they've got to remember is that NDA does not, I hate to use the word trump, that doesn't trump, it doesn't overtake the Public Information Act. The Public Information Act is what it is, and that spells out what public information is. So if an NDA tries to write something into being off limits, but it's allowable under the Public Information Act, the two don't even cross. That NDA is not, I'm not a lawyer here, so you may want to take that specific question to a lawyer, but I've dealt with it enough times to know you can't just write something into an NDA and say it's not subject to the Public Information Act. For instance, there was a situation in a local community college where they hired the new, president of the community college, and they wrote it into the NDA or the so-called, or the contract even, and maybe they called it an NDA, that if he was ever terminated, that the reasons for the termination and the payout amount was off limits. It was non-disclosable under the Public Information Act. No, that did not pan out. You can't do that. The Public Information Act prevails. That's the word I was looking for earlier. It prevails on what's public and what's not. That makes sense. You might have some things in an NDA that are exceptions under the Public Information Act, like maybe certain trade secrets or something, but that's to be determined in the whole AG ruling process and such. It's not just going to stand and a government says, no, you can't have that, there's an NDA. That's not how it works. Does that answer the question?
It does, thank you.
So the next question
So everybody keep in mind, NDAs are way overused these days, and government really shouldn't be doing NDAs, but that we're seeing it.
And so the next question, it's very specifically about part of the Texas Public Information Act, section 552.221. And so this individual was hoping that you could please explain what is meant by shall certify that fact.
Shall certify that fact? Oh, I'm going to have to look that up. Can you tell me more about that section? Because I don't know it all. By heart. I'm going to look it up.
It was on the second slide.
It was on the second slide, Kelly.
Okay, let me sorry. That helps. Thank you.
I think he's referring to.
Oh, gotcha. Okay. Got it. Okay. So when we're talking about sending to the specific address, is that what we're talking about? Or, I see what you mean. The 10 business days when it's got to be produced promptly, And then if you can't, okay, I got you now. Thank you. If the governmental, I just don't know all the provisions of the code, all the numbers without looking it up. If the governmental body cannot produce the public information within 10 business days, it shall certify that fact. In other words, the governmental body shall have to say, look, I can't, this is too much information, or we can't get the information yet. I cannot get it to you within 10 business days. So that's certifying that fact in writing. And then they are supposed to set the date and the hour within a reasonable time about when you can get it. So let's say you put in the Information Act request today, and 2 or 3 days from now the government says, look, we cannot provide that information to you within 10 business days. However, we can provide it by February 26th at 9 a.m. or February 19th, or whatever the date might be. Does that make sense?
My question was, so we don't have to...
Is somebody in the room asking that question?
We don't have to explain to them...
Yes, he's clarifying his question.
So essentially, the question is, does the governmental body have to explain why they are unable to provide the materials within that specified time frame? Or is it enough to simply say, we can't do it within this time frame, here is a certified date and time?
Yeah, no, I think it's the latter. Like, they just need to say, we cannot provide the information by that time. If they want to give a reason, hey, all the better. The more information governments give, the better. They might say, this is all kept in a box down at the county warehouse that we're going to have to go search for, or this is a voluminous request and it's going to take a lot more time. They could say that, but really all they've got to say is,
We lost you. Hold on. You were muted there, Kelly. You're still muted.
Looks like she's still muted.
Huh, how did that happen? Well, that was our last question. Yeah, you're still muted, Kelly, but that was our last question, and we'll let Olivia wrap up.
Yeah, well, thank you everyone for coming to this event, and thank you to our speaker for taking the time to share all of this information with us. I hope everyone got some useful information. If you have more questions, the Freedom of Information Foundation is a great resource, so I'd recommend reaching out to them if there's a specific situation or something else you wanted to know. But yeah, thank you everyone for coming.
Can I have a of the presentation? I really appreciate it.